Greetings everyone, my name is Jonathan Bailey. I'm from the website Plagiarism Today, which can be found at plagiarismtoday.com. I am a copyright and plagiarism expert with 18 years of experience in this field. I have testified as an expert before academic tribunals, state courts, and federal courts. I also am a copyright and plagiarism consultant at Copybyte. That is where you can find all about the various services I offer, and if it sounds like I might be someone who can help you out, you can get in contact with me super easy. This week, I'm kind of hoping to put a pin in the last little bit of the hbomberguy plagiarism video saga. First off, though, I do want to welcome the over 1,500 new subscribers to this channel. Thank you all. I'm blown away at the response to that last video, especially given how bad it looked and how, well, we'll just say imperfect it was. I appreciate everyone's leeway. Your comments in general were very kind. Thank you all for your support, and I'm hoping that we will be able to improve the quality moving forward. Speaking of which, things are already looking a lot better. Lighting is still not fully in, but I'm in the correct place. The wall of crap is looking good. Things are looking up. It's coming up Millhouse around here. But on that note, what I want to talk to you about this week is sort of the final piece of this hbomberguy plagiarism saga, and that is, what about the victims? What do they get to do? What are their options? And that's really, really complicated. There are two main problems with determining what their options are. The first big one is that not every plagiarist is in the exact same situation. I mean, once again, I've put this image up before, but look at it again. This is from one James Sunderland script. This showcases not just how many sources and how much of it was plagiarized, but how different the plagiarism was from source to source. As you can see here, some people had very lengthy passages taken. Others had very short passages in which, only a line or two or a paragraph or two were taken. Each of these individuals are going to find themselves in a different position when it comes to how they respond or what they're able to do legally. In a lot of these cases, yes, it's very likely a plagiarism, but the amount of copying doesn't likely rise to the level of copyright infringement. And that does create a pretty significant problem when trying to respond to this with any kind of legal recourse, we'll say. The second issue, and this is something that we saw in the Internet Historian case rather, is that not every person who was infringed owns the rights to the content that was infringed or copied. Mental Floss, for example, owned the rights from the reporter who wrote that article and spent so much time and dedicated so much of their life to it. Mental Floss, as their employer, was the rights holder, so therefore they were the ones that took action. But my main advice is, if you were plagiarized by James Sunderland, by Illuminati, or by the Internet Historian, anyone else involved in that video, or if you have a new case that's similar but was not covered in the hbomberguy video, the best piece of advice I want to give you right off the bat is seek out an attorney and lay out what happened to them. Let the attorney guide you on this. Trust me, it will save you so much time, and even if it doesn't seem like it in the short term, it will save you a lot of money, especially if you decide to pursue this case in any meaningful way. Trust me, getting with an attorney, sitting down, going over the case is an important step. And once again, I am not an attorney. But let's just say for a second that you did that, and you did determine that your work was infringed and that you are the copyright holder. What is the next step? What is your likely next best option? Well, right off the bat, you're a little bit limited because James Sunderland has already removed everything from his YouTube channel, so that happened. By the way, start your office betting pool now for when he attempts to make his big comeback. I'm going with 6 months, but these are inherently unpredictable, which is why a pool is a lot of fun here. But seriously, put me in for 50 cents on 6 months from now. We'll see how much money I lose on this. But anyways, the point of the matter is, James Sunderland's channel is gone. Illuminati seems to be continuing on, but as was pointed out to me, her channel was facing serious difficulties well before the hbomberguy video, and thank you to all of you who pointed out that it wasn't just the plagiarism allegation, it was the other stuff mentioned in the hbomberguy video that brought her down and basically exposed her in a very, very negative light, we'll just say. It was a lot of stuff, not just a plagiarism. I appreciate the information on that. So yeah, what are the options if you do believe you were infringed and you are the right holder? Well, I'm going to give a spoiler. I'm going to give the big reveal at the beginning because I'm terrible at YouTube, as we've just discussed. But the main thing is I don't think in most cases litigation is terribly practical. And the reasons for this are multiple. These individuals are sprinkled all over the world. But also, and I think more to the point, the amount of infringement and the likelihood of damages one could collect isn't likely to exceed the cost of the case. Now, yes, in many situations, you can get attorney's fees and other damages covered, but that's not every time. A copyright infringement lawsuit is a very expensive gamble, basically. You're gambling that you will be awarded the damages you needed and that you will be able to collect those damages. And honestly, my personal non-lawyer opinion here, those numbers do not line up in these cases. But hey, once again, talk to your lawyer. There may be information I don't have. I'm not perfect. Listen to your lawyers, everyone. That said, there are two main options I do see that are available for most of the people who were infringed. The first is the obvious. File a copyright claim. I know. This is YouTube. We're all familiar with them. And I know here that copyright claims are about as popular as various infectious diseases. But that being said, it is a very, very simple process. It only takes a couple of minutes to do. Look, here's the form. I'm putting up the form right now. You just fill out this form with your information, send it off, and once YouTube processes it and checks the validity and does what they're going to do with it, the content is taken down. Easy peasy. Best of all, if multiple rights holders do it, it's possible that the channel involved will get shut down completely, the entire channel. Yeah, it's a very, very powerful, simple to use tool, and it's one that I recommend rights holders become very familiar with pretty much as soon as possible. Now, that said, there are a few limitations. First, a lot of people are not comfortable about handing their personal information over to YouTube. That's why many people hire DMCA agents to serve as the point of contact for them. That's a service that I do provide at Copybyte. But the big one, and the big reason a lot of people are hesitant to do this, is that it is a time sink. You are spending time. You're spending energy. You're spending, no matter how small the resources, you're spending time, energy, and resources in this with no damages coming back. The only win here is that the video comes down, and possibly, like I said, with enough complaints, the whole channel. I consider that a pretty big win, but I can also see why a lot of people will be hesitant to it. It's much more tempting, much more appealing to try and get some kind of damage, to get some kind of remuneration from this. And that end brings us to the second option, the Copyright Claims Board. Now, you might remember from a few years ago the CASE Act. Basically, it was an act that established a copyright small claims court, though it's technically a claims board. We'll get into the differences in just a second, in which hears smaller cases of copyright infringement. Now, the brilliant side of this is that where a federal court case is incredibly expensive, can take many years, and is very difficult to do, and requires an attorney. The Copyright Claims Board is much less expensive, with the initial filing fee being just $40. You, as a layperson, can do it all yourself. You don't need an attorney, though you can use one if you so desire. And basically, cases tend to be resolved if they're not settled or otherwise dealt with early, or otherwise shunned to the side early, they're usually handled in about a year, maybe 18 months in some of the longer cases. And believe me, in the land of copyright infringement lawsuits, that is incredibly quick. I know it sounds like a long time to wait, and it is, but believe me, it is so much faster than your average federal copyright infringement case. In this court, you can sue for up to $15,000 damages per work, or $30,000 in damages for the total case. So basically, if you're looking for higher damages, I recommend filing only for 2 works, because $30,000 is the cap for the entire case. That said, the damages that have been awarded so far have not been anywhere near that. They've been in the mid 4 figures, typically like the $2,000 to $6,000 range. But still, that's the theoretical maximum for this court. But there are two very important limitations. First, this is not a court. It does not have jurisdiction by itself. That means that the respondent, aka the defendant, well, it would be normally the defendant, the respondent, has the opportunity to simply opt out, say, I don't want to do this. And if they do that, your only recourse is to file a case in federal court. Now, if you have to, that case is going to have a pretty strong argument for significant damages, because you can say, hey, look, I tried to reduce the damages. I tried to go, the cheaper, less expensive route. I tried to make this easier on everyone, but they opted out. Therefore, we have to go this way. I deserve more damages, including attorney's fees. So it does bolster your case in federal court. But still, they can opt out. And if a case isn't practical for federal court before this, it probably isn't after. The second issue, though, is that respondents have to be American citizens or American companies. So right off the bat, that means like James Sunderland, for example. He's based out of Canada, internet historian. Is based out of Australia. They can't be targeted. Illuminati, it appears, can be. She does appear to be located in the United States, but the other big characters in the hbomberguy video are not located in the United States and cannot be targeted by the CCB. Frustrating, but it's also part of this being a board, not a court. Basically, they don't have independent authority. Everyone has to agree and consent to participate into this. Now, granted, if the other side does not opt out, but rather just doesn't respond, they are automatically opted in. And if they don't respond or participate in the hearings, they can be given a default judgment. But that's a separate issue, and collecting on a default judgment from the CCB is its whole own thing that I won't get into. But still, it's important to remember that there is this small claims court mechanism for resolving copyright disputes in the United States if the respondent is a United States citizen or a United States company. I'm going to put links to the CCB and all that stuff, and also links to the YouTube policy for filing copyright notices in the description. So please, once again, links in the description. Check it out. I'm also going to put the text version of this video in the description as well. So, between the two, what do I think is the most likely recourse or the best? Well, obviously the copyright claim process, despite not delivering damages and despite being, sometimes the bane of YouTubers' experience, is obviously the easiest and probably best recourse. In most cases, I think this is how people would be best served, especially if they have not registered or worked to the U.S. Copyright Office or taken other steps that might be necessary or helpful before filing with the CCB. But I do want people to remember that the CCB exists. There are plenty of cases, especially for photographers and visual artists who find their work being misused, where the CCB can be very helpful in getting settlements and also just outright resolving cases. So please, do know that it exists, even if maybe it's not the perfect route for these cases. So on that note, everyone, we're going to move on to some FAQs from things that you guys asked after my last video. Okay, on to FAQs, or rather just responding to some of the more common and more interesting comments that I got. A lot of people pointed out, as did Person, at Person here, that a title of plagiarism expert can technically be applied to James Somerton as well. That is, I suppose, quite true. In fact, I would say he's probably more versed on aspects of plagiarism than I am. Some aspects of plagiarism than I am. I will note that for the record. But I would also like to point out that I still have a job. Just saying. Badger of the Sea, great name, said, one thing I like about hbomberguy's video is that the tone of it has a lot of vibe of I'm not angry, I'm just disappointed, which is way cooler and more effective. Completely agree. This was the plagiarism video we needed, not the one we deserve, so to speak. At Orchestra Online, I felt the major point of hbomberguy's piece was how the plagiarism in question was part of an overall trend toward over-monetization, bad faith, and appropriation of intellectual property that was so ingrained that the plagiarists could not stop their behavior, even after being called out on it over and over, nor could they simply apologize and change their ways, because the entire process appeared to rely on copy-pasting text from others' works. Once again, valid point, and I do agree. I think one of the problems we have on YouTube, and I think this is something hbomberguy touched on, but it's been a problem for some time, is the nature of the way YouTube is monetized puts a heavy focus on quantity, not quality. people who release a smaller number of quality videos often struggle to A, be heard, and B, get monetization in a sea of just stuff. A lot of it not good. I know lately I've been getting recommendations for videos that are just utter AI generated garbage, and that seems to be one of the key directions that YouTube is going these days. Frustrating, yes. Absolutely the nature of the YouTube beast right now. Also, yes, unfortunately. And finally, James Ladler 2152, I just had to include this one, said, "Hold up, a guy plagiarized you for an apology for plagiarism. What the actual Nelly?" By the way, good duck on the swear. Yeah, actually, I put a video about it. It was not a guy, it was a girl. Her name was Jimmy Bello. You can go back. I will put a link to the video in the description. I talked about it there. I've also written a couple of articles about on Plagiarism Today, but yes, that's exactly what happened. I will also link to the episode of NPR's Wait, Wait, Don't Tell Me, where I was the guest on the Guess the False News Story segment. I just forgot the name of that segment, but I was the guest on that, so you can hear my voice there as well. Well, on that note, everyone, thank you very much for joining me for this past little bit. I hope this was informative and educational, and I will see you all shortly with what I hope will be more normal-ish content compared to what this past week has brought. Thank you again.